This one is consideration as an issue on contracts exams. I'm going to give you a quick review of what consideration is, but this isn't really a lecture about that. It's about how consideration appears as an issue on contracts exam. Consideration is one of the components of a valid and binding bilateral contract. You've got offer, acceptance, and consideration. Now, consideration can vary, but generally it's the exchange of something of value. It's money or services, real settle there, goods in Washington and Colorado. It can also be something that you refrain from or that causes you to withhold something. Good example of this, the Seinfeld episode, Master of Your Domain. The general doctrine is that consideration has to be real, but it can be quite small. It can be nominal, and generally the court will enforce a contract. For instance, you pay $1 and your friend gives you the world's worst drawn Airbus 380. Unless this transaction is unconscionable for other reasons, and unconscionability involves a procedural analysis as to how you got there. As long as this is actually bargained for, a court will generally enforce it. So, given this, I think this is the real stickler. This is why consideration doesn't appear that much or doesn't appear very centrally as an issue on contracts exams. Most things are fine, so it won't be an issue. But there are some things to look for. Two things include old consideration and illusory consideration. By old consideration, the factual hook here is that you're going to see multiple transactions, multiple bilateral contracts that are set up. Maybe just two, you don't even need three. Contract A is, say, a rental contract for $2,000 a month in a house, and that's you. Contract B is rent to own that crappy Snoopy doghouse for 50% of rent already paid, plus 50% in the future. Now that sounds like actual money, but in reality, the person who's renting doesn't have to pay $1 more, not $1 more under this contract B. So in this situation, there's no consideration for contract B. This guy who's renting the house can't enforce the rent-to-own contract because he hasn't actually paid anything on top of his rental fee. With illusory consideration, the problem is different. It's the wording of the... Let's say you've got a couple of guys. Here you've got Nacho Man! And business is down after the Super Bowl, but he makes nachos. That is a nacho. And this is Nacho Eater. They enter a contract. Nacho Man is obligated to sell Nacho Eater every nacho he makes. Nacho Eater, secretly Cartman, is obligated to buy all the nachos he wants. This is an illusory contract. He's not really tied down to anything, whereas he's not able to sell to, like, Tiny Tim over here. Please, sir. And now I'm mixing Dickens. Can I have some more? Who actually needs to eat because he has to sell to Nacho Eater, but if he feels like it, he can just not buy them. So those are the two hooks to look out for consideration issues. Normally, with this, you can just go through the motions, and at least in setting up a bilateral contract on an exam, you can say, here, it looks like there's sufficient consideration here. You don't need to touch it more than that. But if you see these two hooks, one is multiple contracts, and the second one piggybacks off the first one, you've got old consideration, an existing legal obligation, and consideration's not valid. In the second instance, you've got Nacho Man. Don't forget Nacho Man. Poor Nacho Man. Be attentive to the precise contractual language. If the second person can do whatever he wants and has no obligation to accept things, that's not a real contract.